Hello. Welcome to From the Gallery Live with Lone Wolf Usul. It's another Saturday morning. I'm happy to see everybody here. It's going to be an interesting one today. It's going to be a very interesting one today. It's chock full of Sov Cits or Sov Cit adjacents. There are a couple here that I will put a little asterisk next to. The very first one to note, we got an interesting first block. We're gonna start it off with Norbik. Gonna move on into some Fleischer, and then we're gonna find our way into some Norbik. Oh wait, oh my lord, I have forgotten the guy's name. Moblek. I have it notated on the video. It's cool. Thank you everybody for showing up today. We're getting started. Welcome to From the Gallery Live. I am your host, Lone Wolf Usul. Hello, everybody. I am your Lone Wolf Usul. We're going to get this thing started. We're not going to mess around. We have a hefty one today. Like I said just a minute ago, we're starting off with a block of 3 different judges. I kind of like to look at it like this. There are 3 judges handling these different situations in very different manners. Look at this. Look at this. You see this, right? I can't do anything. We can't have anything nice. He's the boss of everything, right? So we're gonna get right into it. This tells me that I'm already talking too much, so why not? Let's all enjoy these videos together, shall we?
Good afternoon, your name?
Dylan Edward Hall, Your Honor.
Mr. Hall, these look like they are old cases, not new cases, so that's good news. Bad news is they're all show causes that you have multiple failures to show. My options are to just let you sit in jail or let you out of jail because you're telling me something's going to be different if I let you out.
Your Honor, I was incarcerated since October. That's why I failed to appear for it.
Well, these are going back to 2014. you failed to show. What I say is a bunch of times it's over the years. Are you incarcerated on anything else?
No,
right now. All right.
No,
so if I let you out, you go back into the world. Is your plan to get a job, start working?
I have a job with the Department of Justice right now, so yes, I'm gonna pay it. I just have to get to my paycheck.
All right, what I'm gonna do is, I'm not gonna hold you in jail on old cases. I'm gonna release you from jail. We will set this for review in 90 days. You don't have to
Oh, hell.
pay. I could read to you the dollar amounts on these. I'm not sure if you're aware.
It
But
doesn't matter what
essentially,
it is. I can pay it all at
Yeah.
once as soon as I get.
essentially is you don't have to pay it all at once. We just need you to make some sort of progress towards zero. When you get out of jail, if you actually put some money on these, you maybe wouldn't even have to come to that next court date in 90 days. But if you do nothing and come back in 90 days.
I understand. Yeah, I'm gonna just pay it all. You know, since my Aunt Elizabeth died in the United Kingdom, I got quite a bit of money now, so.
All right, well then you're all set. You can go ahead and go. Here's the sheets. We're about to go.
Step up this way. Step up this way.
I don't understand what's.
Sir, you're here for your first appearance. We're getting you in front of the judge. So I'm asking you to step up here so you can go through this process.
Stephen, this is about to go really poorly, really quick. Come up, sir.
Okay.
It's gonna go bad for you regardless. Just wait. You now stand charged with your third case, sir.
What?
You now stand charged with resisting arrest and failure to identify oneself as a fugitive from justice. You're now facing an additional year on each case. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
I don't understand. I don't understand.
Sir,
You do not have
Explain it
the,
to you right
I have the
now.
right to arrest me. I did nothing wrong.
Let's see.
I did nothing wrong. You do not have,
in this courtroom.
I do not have, you do not have the right to arrest me. You do not. Are you acting under your constitutional oath today? Are you?
Yes.
You are? Okay, well, good. You are in agreement with the prosecutor, right? I make a motion that this case be dismissed.
I'm about to hold you in contempt if you.
For what? In order for there to be a crime, there has to be an injured person. The only person injured is me, and I have the scars from the policy officers beating me, pulling me out of my car without even telling me why.
Going to do.
I don't understand.
You have the right to
I
remain
do not
silent.
understand.
One more word and
I
I'm.
do not, you can't do that. In order for there to be a crime, you're not, this is against my constitutional rights.
Okay, you know.
Do I have a witness that they are committing treason? Do I have at least 2 witnesses? Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights. They are violating my rights.
Hey,
Look, see, that's what I'm talking about. Look.
Put your hands behind your back.
No, sir.
Put your hands behind
You're violating my rights, and you all know it. The public prosecutor is there, a court reporter.
Put your hands behind your back.
I'm not doing anything wrong. Do I have 2 witnesses saying? Do I have 2 witnesses that say that they're committing treason? Please raise your hand. Do I have 2 witnesses that they're committing treason?
Sir.
Do I have 2 witnesses that they're committing treason?
Quit resisting.
Raise your hand. Are you raising your hands?
That would be the taser.
Take the taser off me.
Put your hand. Move your hand.
Do I have 2 witnesses? Do I have 2 witnesses that they are committing treason? Raise your hand, stand up. Stand up for America. They are committing treason. They are committing treason. Raise your hands. No one. They are violating the Constitution. They are violating the Constitution. Oh!
Stop.
I have no cartilage in my left arm.
Stop resisting.
As the medical report shows, when y'all last officers last beat me up, I had to go to the hospital.
I'm trying to lift you up properly, but you will not stop resisting.
Man,
Hey, Karen. Silence.
I can't believe none of y'all, they're violating the Constitution. This is treason. Raise your hand. I need 2 witnesses. I need 2 witnesses. The officers, y'all are going against your constitutional oath.
cause number 88C01-2210 F1833, State of Indiana versus Dijon Anderson. Ms. Anderson, for the record, would you state your full name, please?
Yes, I am Princess Califia Hatan Tupape II, representing the entity Dejon Anderson.
You're known as Dijon Anderson.
I'm representing the entity as Dejon Anderson.
Your date of birth?
My date of birth is February 2nd, 1961.
That would make you how old?
That'll make me 63 years old.
And the last 4 digits, your social security number?
I do not have a social security number. I have a declaration of nationality underneath the Washita Moors of the Indigenous People of the United Nations, Chapter 221593.
Are you under the influence of any drugs, including alcohol today?
No, I'm not.
You read and understand the English language?
Yes, I do.
If I say something you don't understand, will you let me know?
I will most definitely will.
Ms. Anderson, Officer Busick, who's investigated this, looked for you for the past 2 years, and Prosecutor Hunt have charged you with 3 counts of criminal conduct. Count 1 is murder as a felony, would indicate that between April the 10th, 2022, and April the 16th, 2022, in Washington County, State of Indiana, you did knowingly or intentionally kill another human being, that being child victim number 1, contrary to the form of the statute in such cases made and provided by Indiana Code 35-42-1-1, parentheses 1, and against the peace and dignity of the state of Indiana. Count 2, neglect of a dependent resulting in death as a level 1 felony, would indicate between December the 1st, 2021 and April the 16th, 2022 in Washington County, State of Indiana, you being at least 18 years of age and having the care of child victim 1, a dependent, less than 14 years of age, did knowingly place said dependent in a situation that endangered the dependent's life or health and which resulted in the death of child victim number 1. Count 3, obstruction of justice as a level 6 felony, would indicate that between April the 10th, 2022 and April the 16th, 2022 in Washington County, State of Indiana, you did alter, damage, or remove a record, document, or thing with the intent to prevent said item from being produced or used as evidence in a legal proceeding or an administrative or criminal investigation, contrary to the form of the statutes made in such case provided. The murder, a felony, has a range of imprisonment from 45 years to 65 years, with the advisory sentence being 55 years and up to a $10,000 fine. The level 1 felony, neglect of a dependent resulting in death, has a range of imprisonment from 20 years to 40 years, with the advisory sentence being 30 years and up to a $10,000 fine. And the level 6 felony has a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
I do understand.
Okay. And do you understand the potential penalties?
I do.
Do you intend to hire a lawyer, or is someone likely to hire a lawyer for you?
I want to file a motion for self-representation.
You understand if you do that, you are required to conduct yourself as a lawyer to be able to board our potential jurors, to abide by the rules of evidence, to abide by the rules of procedure.
I do understand. I have a master's in history,
That doesn't give you a law degree, though.
but I do understand how to read procedures and understand the court procedures.
Right. Just because you represent yourself, that doesn't ensure yourself of a good lawyer, you know.
That's a personal opinion, but I understand.
Make your request in writing, okay?
I will, most definitely.
Uh,
Can you give me at least just like 5 days and I could get it
I
to you?
can certainly give you 5 days to do it. I think what my intention would be, let me ask you this. Can you afford a lawyer?
It's not that I can't afford a lawyer, it's that I want to do self-representation due to, I understand the nature of my case, and I understand that this is my life on the line, and I do understand that there are things that involve my case as far as the evidence that I hold, which is Q classified evidence, which should be turned over to Judge Advocate General Courts immediately, if possible. Because my case involves other cases that are open currently with Judge Advocate General Courts, as well as federal investigations that are open.
What are you talking about?
Well, if the Judge Advocate General approaches us, we'll address it at that point in time.
Okay.
How about I appoint you standby counsel?
Oh, no, thank you.
No, thank you. All right. You make your written request. I need to advise you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, to hear, question, and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf, and at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf and bring evidence in. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone. You do have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning your rights?
No, I do not.
Okay. Then I will set this matter for a pretrial conference on the 25th day of April at 9 a.m. A trial date of the 6th day of August of this year at 8:30 a.m. and an omnibus date of June the 15th. Do you have any questions at all?
No, I do not have any questions.
All right. You'll sign this reappearance slip. We'll discuss the issue of bond. Ms. Hunt, what's the state's position?
Yes, Your Honor. Given the gravity of this case, first of all, I would like for you just to take judicial notice of the probable cause affidavit that the state filed in support of these 3 charges, which resulted in the arrest warrant. I'd also like to bring to the judge's attention that it's almost a 2-year mark of officers locating this, at the time, unidentified little boy in the woods. So I would argue that the defendant has been a fugitive since that time. Her identification has been made. I think that raises any bond in a murder case to be something of the utmost importance and should be of an amount that should be very difficult, if not impractical, for her to be able to afford, or I feel she will be abscond from this court. She's never been from Indiana. She's not from Washington County, is my understanding. She was located in California. So on that reserve, I would leave that to the court. And if further motion is needed on the state's behalf, I will make that.
Thank you. Ms. Anderson, you just made an objection.
Yes.
State the basis of your objection.
The basis of my objection is the fact that I am not a fugitive. I have been under NSA surveillance for the past 8 months. And how can that qualify me as a fugitive on the run when I've also had a detail from Space Force that was following my every move when I contacted the Indiana State to arrest me?
That is not a valid legal objection. If you want to represent yourself, you're going to have to learn the rules of evidence and the rules of procedure, because if you conduct yourself like this and make these types of objections, you have no chance in the world, lady.
Okay.
So, objection overruled. I will let you make argument in regards to bond.
Okay. Well, thank you. So that's my argument is that I have been under surveillance by NSA for over 8 months. I also have a detail that follows me everywhere I go from Space Force military. I also contacted Indiana State. I think it was a federal marshal that I called to have my location tracked to pick me up. So there's no type of extent of me running where I need this astronomical bond on my charges.
Well, that's sort of interesting because it's my understanding Officer Busick has been in touch with almost every one of those agencies and they haven't been able to identify your location until recently. So I'm going to set your bond at no bond at this particular point in time. If Space Force comes forward and tells me that they're willing to monitor you, we'll take up the issue of bond at a later time.
Okay.
Anything else?
No, Your Honor.
All right, we'll be off record at 1:44. You can.
Well, that's the first block. Those are 3 different judges handling 3 extremely different situations in an extremely different fashion. We're going to move on to a more traditional Sov Cit now and just look at some poor judges in frustrating situations. First up is going to be Judge Perkins. Then we're going to move on to Judge Washington. And we have a whole set of Judge Simpson goodness to finish things off for the day. So stick around and we're going right into Perkins right now.
Mr. Christopher Lewis, are you there?
Yes, how you doing?
I'm very good. Christopher Lewis. Lewis from the docket. Christopher Lewis.
Fine.
City of Detroit versus Christopher Perry Lewis. Case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Okay, I apologize.
Thank you.
All right, today is the date. Good morning, Mr. Lewis. Today is the date and time set for a hearing on the bench warrant. I'm going to enter a not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and I'll put my email so you'll have it. And send that to me, and I'll have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sent it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her an attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that we have. All right. I'm gonna wait on that. Once I confirm that you gave me that, I will recall the case. All right, let's pass that matter.
Thank you, Mr. Patel.
All right, let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion. Because
I would just appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay. You were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying the motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay, I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there, overwhelming. So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay. And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue, because you're Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime. Ain't no victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence, or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it.
This
This due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever, wait a minute, let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
I appreciate that, but I was still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not you know, I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that of the United States Constitution, indicating a clear conflict of interest. I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, so you want a trial date? Give me a jury trial date, please, Ms. Memphis. And you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you
The
coming
36th
down.
district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
It looks like it's going to be July the 23rd.
Before you say that again, Ms. Mathis, just verify it before you say it. Please, the dates.
Okay, I'm just checking.
I know, but you're thinking out loud.
Okay, I'm sorry.
Good day.
Yes.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that day. So you're trying to play with me. You could dismiss it today, sir. You literally, but violating my due process. You are literally violating my due process. You can't even give me a written excuse, but you're going to all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial July 22nd. The final date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
I don't know. Mr. Lewis, I'm sorry. Have a very good day. Best of luck to you.
And it's an excellent example of the frustration that our judges go through in the process of dealing with these crazy people. Absolutely nutty. It doesn't get any better for Judge Washington. She's got a gentleman named Eric Martin in her court. People may have already seen this one, but I haven't seen all of it all the way through, but we're going to watch it here together. It's your time to shine and comment as you like. Get into Judge Washington and enjoy this together.
We'll see you then, okay?
Yes, ma'am.
All right, take care of yourself.
You too, hon.
Bye-bye.
Have a good day.
All right, the court will call the case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family, a living sovereign, one of the people.
Assistant Public Defender Don Lebo as standby counsel.
Thank you. We're here for a pretrial today. And a bench warrant is still outstanding for Mr. Martin?
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I found I looked at the video, and I also found some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all the motions that you brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not prepared?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't style it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to that. The third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're going to need to speak up if you want to have a transcript of this because it's not.
I'm speaking up.
Let's see, Heather. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
Kind of a little closer now. How's that?
Is that any better?
How's that?
How's that? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Benton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now, I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your
I'm
Honor,
putting a
since
stop to it.
Mr. I'm sorry, Mr. Martin, since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
See no order.
Is that the May jury selection, Your Honor? Or
no, it's not. We're gonna do a July 25th jury, July 25th final settlement conference.
Okay.
August 9th.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
And I'm also going to make a demand right now for a compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery. All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. It was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going to tell him in just 1 second. All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on, July 25th, 24, right? 8 p.m. a.m. You said, right?
It's at 11 a.m., sir.
You know, I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said July 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the what's the other date now? August. What else?
August 9th
Okay.
at
What time?
8:30.
8:30, and what's that considered? What's that called there?
Jury selection, sir.
Now, which is in person here now? The site 24, is that something I have to be there in person for? I'm being
For the fourth
threatened to come
time,
up there.
Mr. Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
We got it. So you're saying a whole bunch of,
All right, we're
Yeah,
done today. Have a good day, Mr. Martin. Bye-bye.
Brat! So happy to see you. Yay. So happy to see everybody who has showed out today. Thank you for showing up. We have one more block, and that block is Judge Simpson Strong, ladies and gentlemen. We have one for sure sovereign citizen, no questions about it. A second one that is very probably some sort of weird kind of sovereign adjacent / angry person thing. And then we're going to follow it up with just an all-around crappy guy. The last two in the set here are actually people we've seen before. These are kind of updates. The one is the lady who you'll see. Judge Simpson was like, oh no, and sent Alan after. The last guy is the guy who Judge Simpson basically told him off recently. I did throw the recaps in for those videos, so we are going to just power into Judge Simpson and enjoy the last little bit of this block. Thank everybody for showing up. I'll see everybody after the Judge Simpson block, and we'll chat for a few minutes, and we'll say have a great day. But first, Judge Simpson.
That's your notice for your next.
Court calls case People versus Tariq Day.
Ramesh Ganatra, Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samara Tariq Day here.
Already, Judge. Court Officer Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I could.
In a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital starting the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're gonna represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Folks, why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill, and it's those two guys' fault talking to each other. Orders in recess.
All rise. May be seated.
Let's call the case, People State of Michigan versus Tariq Day.
Michigan Atra, Senior Assistant Prosecuting Attorney for the people.
What's your name?
Tariq Samar Tariq, the executive of the Tariq Samar Tariq Living Trust. Glad owner Tariq Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of
Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demurrer. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and under they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. Mansour, are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant. How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him?
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have a an address on, is it share?
I do, Your Honor.
Okay. Okay, gotcha. All right. You'll make sure that that is sent to him. You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing.
What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that.
All right. So here's what we'll do because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step. And I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine. And then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person?
To provide, to accumulate my documents for my defense.
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm gonna set it 25th.
I mean, I was on the call. I've heard you give multiple councils extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
Just for the record, I'll put it on the record that I object, but under threat, duress, or coercion, again.
Your objection is noted.
Right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or I get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed, or I'm trying to figure out how do I get the paperwork?
You can check out at the front counter.
Okay, thank you. That's all I have.
Court calls the case, People versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor. I'm dismissing my court-appointed attorney and representing myself.
Okay, so start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon representing yourself in this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
What I'm trying, I have not done so.
Okay.
So I'm trying to figure out what the issue is and what you're intending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry, at this time. I can't make it any clearer, and I don't understand.
You're not making it very clear to me at all.
Okay,
You're not listening.
I'm
You're just
confused.
talking. Are you going to hire an attorney?
Yes.
Or are you going to represent yourself?
Today, Your Honor, I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
So you're gonna, so if I relieve Mr. Drukas, you're going to represent yourself.
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No.
Okay, well, I don't.
Listen. You don't you dare just lean on my podium and pretend like that. Not here. Okay, here's what I'm gonna do. I'm gonna pass the matter because if you come back up and start banging your nails on that podium, you're gonna be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Thank you, Mr. Durkin. Okay, so who wants to go next? Christian Philippe. Recalls the case, People versus Witsit.
And Edward Drukas on behalf of Chloe Whitsett.
Your name.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding, but yes, that is correct.
Ms. Whitsett, let me tell you something. I should have locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions. And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, it's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone. So while you may not want him representing you, he just saved you. Remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th, 2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you.
Court does call the case, People State of Michigan versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett.
Chloe Whitsett.
Okay.
Your Honor, today's time of day set for probable cause conference. We adjourned last time for her to obtain counsel. My update from last time is she does report to me that she did obtain counsel and would plan to have them here at the next hearing. On her behalf, I'd ask for an adjournment.
Counsel approach. Counsel approach. Ma'am, have you retained other counsel? I think you indicated that the last time.
Yes, I have. But it was very last minute when I paid them. And again, the counsel that I have retained, I really did not want to say the name of the Perkins group, but the attorney is either a representative directly of the Todd Russell Perkins group or a referral from him, because like I said, this is a favor. I was telling him that it's a favor to me. He's not even charging me what he charges normal people. I didn't even give him what
Okay,
Just as in my
I don't
bond.
need to know all of that.
Yeah, well, I'm just saying,
But
yes.
what
I
I'm
have.
gonna do is I'll adjourn this out 2 weeks to the 25th at 9 a.m. or your time that's set by the
That's
board.
fine. That's enough time.
And ma'am, the last time that you were here, we had a problem, and I'm just gonna call it what is your attitude or somewhat your demeanor. And that, I thought we were straight when you left, but you're sending what at least people are considering harassing emails to the Department of Community Corrections.
Mhm.
Outside of what's required.
That's why I'm asking.
I think when she's
Can it be modified is what I'm saying, because
right now, they're not going to modify it. You can ask to modify it the next court date.
okay, yes, they will.
Ma'am, I don't want, there is no reason for you to be emailing them.
Well, they were,
No,
sir, no communications.
They
Other than
call
to
you,
drop.
you talk to them, that's it. But
sir.
this stuff, I don't know why you're trying to do this. Because this is just, you almost got yourself locked up the last time that you were here. By me. And finally, you got yourself calmed down. I passed it because I didn't know what was bothering you. I passed it. When you left the podium and you left my courtroom, I thought we were all on the same page about how people should be treated and how we were going to do everything. And then I get here now and I get this. So I'm just going to tell you, I don't want anything improper. If you've got an attorney and you've got to, for whatever reason, express something or communicate, tell your attorney and have them communicate with community corrections. I'm just going to give you this admonition. If I get something like this again, I'm likely going to revoke your bond. Did you hear me, ma'am?
Yes, sir.
All right. I just don't want to see it. There's no reason for it. See you on the 25th. Bond will continue.
Thank you, Ron.
It until 3?
Yes, sir.
Really? Ooh, I caught up. Court stands in recess. You can remain. Man, you need to, no, just do my thing. No, I'm gonna let you go. I'm gonna let you go. I'm gonna leave. Just go ahead.
All right.
All right. Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything.
Right, exactly.
I'm
Probably
going,
cause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes this hearing. Court does call the case. The people of the state of Michigan versus Cody Lee Jolly. We're actually set for, what are we set for? Well, except for PCC. All right, state your name, sir.
Cody Lee Joe.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration, $500 fine plus court cost mandatory STD testing. You understand that, sir?
Yeah.
All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right, so what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. The CD provided to the jail staff.
Yeah.
If the answer is no, I don't sort of have that. Okay. Could you put it in? Is that acceptable? Is that okay with you guys? Okay, thank you so much.
All right.
So that's everything we have.
All right, that's all discovery. Sir, what did you want to do next on this case?
Before I guess start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay. That's what concerns me. You're charged with a high court misdemeanor. Okay. The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay. And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty. Case to get preliminary examinations. Okay. I have this matter. I'm in custody right now. And I was hoping to settle to solve it.
So you want it? You got a copy of the police report, right?
I got the discovery. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible. But if the preliminary examination goes before that.
Wow. Yeah. All right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person.
In this matter, the custody includes
Pardon?
The other day I went to the arraignment. I was hoping that to get released, but there was, I had to come here first. Can I get released through this?
What do you mean? You,
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has, historically, he has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was arrested on April 5th, 2024. He was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC. He's out on bond in the CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is a violation of his bond, given that he's committing a new crime while he's out on bond, and that's concerning behavior in a public place, in a place he's in trespass. My office denied the warrant request and essentially turned to this case and for us to move forward on violation here instead.
all right, sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was, they said that it was, when they came out and gave me this trespass, when I got here, they said that trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because what the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. Yeah, nothing weird in the library. I have no idea. But yeah, I wasn't.
But you weren't supposed to be back on the property.
That's what they said. I guess that was stemming from this. So,
do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
Right. I mean, if it's not a new charge, I admit that I was trespassed. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever. I'm not. Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. Just you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
In a public library, I've never been there before. I wasn't aware that I wasn't allowed to be in a public library. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff we can get it heard. Simple as that. I've done 10 days in jail already. And
Where are you coming up with this 10 days in jail?
just got
Yeah, but what do you mean I've done my 10 days?
I've done 10 days so far, and I've not actually had the charge. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Okay, but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what they're telling me.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
Best I can. I've been 2 months without a problem. Best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you have one, you're going to have a hearing on it. But then the issue becomes, are you going to try to handle this hearing yourself? Or are you going to want an attorney to assist you with that? I understand that you want to move forward, but there's going to be a hearing that's going to determine whether or not you're in custody. Pardon?
As soon as possible.
Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Just like I said, I'm just doing my best to live my life.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm going to let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's going to be held on this case. I'm going to I'll give him a bond of some type, but he's going to be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just facts.
Just answer my question. You're gonna handle it yourself. Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here.
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then because the following week is his, what day?
So we would have Tuesday morning available, but.
The 16th.
But he's in custody, so I would do that. Because that's pretty much he's in custody. Once we did it.
What, I got stuff Tuesday afternoon.
You have an expungement docket at 1, which is small, so you can do it at 2:00.
I could do it at 2:00 on Tuesday, the 16th.
It's a U of M police officer, so I can email him to U of M police officer, so I can email them and see if one or both of them can be there on that date.
Okay. What I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing April 16th, 2024 at 2 p.m. At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender division. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, I can't afford cash bonds or something, just write a PR on it, maybe sign that I've got it.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
No matter how the judge handles the Sov Cit or the Sov Cit adjacent situation, it's always a frustrating situation for the judge to handle. And that's the lesson of today's Saturday live stream. I don't have a lot to say. It's been a blast hanging out with everybody and reading the text and stuff. Thank you. I haven't talked to anybody. It's not really the style of the stream, but you know, we are what we are. We do what we do. I am your Lone Wolf Usul, and it's been a hot hour and 45 minutes of awesomeness. I thought those videos were pretty cool. I thank everybody for coming out. I thank everybody for commenting on the videos. You have, in essence, participated in making some new videos for the channel with me today. That was fun, right? Hey, gonna be doing it next Saturday again. Don't know what kind of theme we'll be going for. Don't know what'll happen. We'll see what happens during the week. I still actually have a van block, like sitting back in the wings, that I found that I haven't published and really haven't gone through yet. So we might have some van just, you know, if we need to fill some time, something like that, we might do some van. I don't know what it, we'll see. We'll see what happens. But thank you all so much for coming out. Thank you for hanging out today. It's been a blast, and I'm going to say that 100 more times. And it's not even going to matter. It really doesn't matter. All that matters is that's the wrong song. That's the right song. All that matters is that is the correct song. That's Yin Yang Stories by Rural Seif. I can't even say the name, but that's what that is. That's Rural Seif. Rural Seif, Yin Yang Stories. Great song. It's also the outro song. Ladies and gentlemen, I am your Lone Wolf Usul. This has been Live from the Gallery, and I have been your curator and host and happy presenter. And I hope you all have a great rest of your day, and we'll see you next time.